Hi, welcome to part 2 of our AI and Antitrust Enforcement series. My name is Camila Ringeling and I am a Senior Fellow at the GW Competition and Innovation Lab. Today we'll examine how algorithms raise economic and legal questions regarding key antitrust concepts such as agreement, intent, and coordination. The current US docket of algorithm-related cases highlights these questions, and how courts decide these matters will have important implications on how companies do business in increasingly AI-driven markets. I am thrilled to be joined today by an outstanding panel of experts. Judge Ginsburg is a senior judge at the U.S. Court of Appeals of the D.C. Circuit and a professor of law at George Mason's University Antonin Scalia Law School. Judge Ginsburg is one of the most respected figures in American antitrust jurisprudence. Koren W Wong-Ervin is a partner at Jones Day. She has over 20 years of experience in government as in-house counsel and representing clients in a wide range of antitrust matters. She was at the FTC. Koren served as an attorney advisor to a commissioner and as counsel for intellectual property and international antitrust. Professor Salil Mehra is a professor of law and government at Temple University, Beasley School of Law. Professor Mehra's research focuses on antitrust, comparative competition law, and the growing influence of artificial intelligence and algorithmic systems on market regulation and enforcement. Professor Maurice Stucke is a professor of law at the University of Tennessee. He also has over 30 years of experience on antitrust, including private practice. He was also a prosecutor at the Department of Justice and a senior policy advisor to the Federal Trade Commission during the Biden administration. And finally, Dr. AI Deng is a managing director of the Berkeley Research Group. He directs the new AI and Advanced Analytics Lab of that research group. He has over 20 years of experience in economic consulting, and he is constantly consulted by competition agencies around the world on AI collusion. And one of the latest agencies to cite his works was the Peruvian Indecopy. So let's start by grounding the conversation in the economic and technical foundations behind algorithmic coordination. Starting with Professor Stucke, in what ways can AI pricing mechanisms facilitate a collusive agreement or a collusive market outcome?
Okay, there are at least 6 scenarios where you can have algorithmic collusion. And the first one is the easiest one. It's express collusion facilitated by algorithms. This is the case where rivals agree to collude and use the pricing algorithm to perfect their conspiracy. And you saw this in the UK with the Trott decision and the US with the case against David Tompkins. And here, what are sort of key features is there's an inclusive agreement between humans. There's programming specific algorithms to facilitate that collusion. And then you see what you would typically see with cartels: ongoing communication, monitoring, punishment, as well as the market conditions make it susceptible to collusion. The second, this arose in Europe with resale price maintenance. And this is where retailers or the manufacturers use algorithms to help perfect their resale price maintenance scheme. And again, what you see is an collusive agreement among humans and programming specific algorithms to help facilitate that RPM. The third scenario is what we're going to talk about today, is algorithmic hub and spoke collusion. And typically here, what you see is the outsourcing of pricing to a hub, and that having then anti-competitive effects. And typically you would expect this to arise in areas where the hub and the participants collectively have market power. They're using the same or similar pricing algorithm. What's unique is the use of non-public information to train the algorithm and arrive at the super competitive pricing. There's the information exchange and the belief how this is going to then raise all the ships. And then you also have the level of integration. To what degree do the market participants have discretion in their own pricing decision? And then there's also the issues about monitoring and punishment, and then also the recruitment of rivals. The next scenario, tacit algorithmic collusion, is actually it's slightly different. And here it's like each company uses a algorithm and with the anti-competitive intent of reaching a super competitive outcome. So there's no agreement, but you have evidence of anti-competitive intent. And this might happen in industries where they may be on the verge of tacit collusion and algorithms can help tip it over. The fifth scenario, this is actually the coolest one, is AI. And here, unbeknownst to the individuals, the AI then is able to reach collusive pricing on its own. So it's not necessarily trained to do so. There isn't necessarily the intent, but through self-learning, the algorithms then arrive at the super competitive price. And then the last scenario, which we call secondary tacit collusion, is where you have a series of hubs and they are then pricing, providing pricing services to the spokes. And the hubs learn to tacitly collude. And one of cases, one of the few cases that we have where the economists have studied is the German gasoline case. That seems to be a case involving secondary tacit collusion. And then another one, they just cited our paper on this, is hotel pricing in Europe. Seems to be following this as well, according to several economists. So those are the 6 different areas. There may be others as well, but these are the 6 ones that have been commonly identified.
Thank you. And Dr. Deng, moving into the economics perspective, how do we think about autonomous collusion by algorithms when antitrust law requires an agreement? How do AIs reach an agreement in the human sense? You've analyzed how machine learning systems can self-learn collusive behavior. Are machine learning systems creating self-stabilizing cartels? These are all questions that we would love an economic perspective on.
Absolutely. First of all, thank you, Camila. And then let me first say that it's such an honor to be on this panel today. So thank you so much for inviting me. So I think you raised 2 really interesting questions. And to emphasize, I want to talk about autonomous AI collusion. I think this is one of the types that Maurice just mentioned, and that is collusion without any human intervention. Now, if humans are involved, I think that refers to the type 1 in Maurice's description, then we're essentially back to the traditional scenario. Now, now when it comes to autonomous AI, and there's been quite a bit of discussion or even debate, if you will, some might even call the debate philosophical about whether AIs are conscious, sentient, or have intent. I think it's safe to say that that debate will continue for a long time. Now, the good news is that we have an economic definition of collusion that does not require us to settle this sort of philosophical debate. An economic definition of collusion will be based on a hallmark feature of cartel based on game theory. And that feature is a reward and punishment scheme. The idea is simply that firms would reward each other by keeping prices high if everyone does the same, but they also commit to punishing a cheater by starting a price war. Now, this definition has been adopted by multiple economic research studies on algorithmic collusion. Now, turning to your second question, Camila, research has shown that it is possible to design collusive algorithms. And that is, if the design objective is to collude or solicit collusion from your competitors, then yes, absolutely, one can design and develop such an algorithm, at least in experimental settings. Now, what remains somewhat unresolved is whether an algorithm that is designed to, say, maximize the firm's profits autonomously learn to collude. I think this is the 5th type of algorithmic collusion that Maurice just mentioned. Now, there was some early evidence indicating that the answer might be yes, but more recent research has started casting some doubt on those earlier claims. Now, without getting into too much details, given the time constraint, I welcome and encourage everyone to check out an article of mine where I recount this nascent field of research, and starting from earlier evidence to the more recent evidence that suggests the answer may not be as clear as we thought as to whether a machine can autonomously learn to collude.
And shifting towards the more legal concept, for Professor Mehra, how should antitrust law conceptualize agreement in the framework of this conduct that Dr. Deng was describing as a matter of shared code, outcome, or intent. What distinguishes legal tacit collusion from explicit collusion in the AI context?
I think the courts are definitely struggling with this. We see this in a number of opinions. Traditionally, antitrust law has distinguished the idea of an agreement, express collusion versus tacit collusion, try to distinguish express collusion from interdependence in a number of ways, right? By looking at factors such as whether the actions at issue are transparent or non-transparent, say secret, whether there's communication between competitors, and also whether they're doing the sort of things that we would tend to see as against the interest of a normal competitor, like sharing sensitive non-public information about their operations, something most businesses don't do. And so, you have the classic example, right, of the gas stations with their posted prices, and maybe that leads to higher pricing through interdependent behavior. But notice that is quite transparent. I think we're still progressing in this area. We're still trying to formulate approaches, but I do think that some of these classic touchstones in terms of the sort of plus factors that you see in the case law, even if we don't apply it exactly the same way as we did in the past, since we're in a very different technological context, I think they do provide some guidance for trying to distinguish, as you say, tacit from explicit collusion in AI-driven markets. Specifically, this idea that the sharing of information that is sensitive in a non-transparent way, and with a third-party provider that is also communicating with your competitors, all of these things are the kinds of things that if we had put them in the past, in the brick and mortar world, and they involved, letters going back and forth or faxes, we would have thought these were the sort of indicia from which you could infer an agreement. You might not compel a finding of an agreement, but a fact finder could infer an explicit agreement. And I think we probably, and we can get more into the case law and some of the things that have come up later in this talk, but we probably should use that as a starting approach. I do want to say, we had a couple of cases about casino hotels and the same exact software, Rainmaker, which was acquired by Sendin in their Group Rev and Guest Rev particular tools. And I think that both of the opinions so far, the one in the Ninth Circuit and the one in the Eastern District of Pennsylvania, they were struggling a little bit with this distinction. I think
we might be losing connection.
I think Professor Mehra froze, but I think the rest of us are here.
Okay. So while we wait for him to come back, Corinne, can you share some thoughts on the same sort of topic of distinguishing tacit versus explicit collusion?
Sure. I'm going to actually step back for the opening remarks and make two main points. And before I do, I'll just say that my remarks are my own and should not be attributed to Jones Day or any firm client. So my first point is really the importance of starting with challenging assumptions about how specific AI and other algorithmic tools work as a technical matter. And here I think it's really important for both the agencies and private parties to involve computer scientists early, both in deciding whether to bring a case and also as part of a risk assessment. I think there's a common assumption, or at least that I've heard, that many of these AI pricing programs are maximizing profits jointly. And this may or may not be true, and it certainly can't be assumed. So, for example, there's a lot of software that's customizable and allows competitors to set different outcomes. So I like this example. Let's take an example where there's 3 firms in a market and they all use the same AI pricing program. Two of them set it so that they're maximizing profits over relatively the same time horizon. And the third says, no, I want to maximize my share, such that that firm ends up becoming a maverick, charging lower prices. So unless that maverick firm is capacity constrained, it's highly unlikely that the two other firms can profitably compete by charging the higher common price recommended by the algorithm. So I think this is very important, and it can really mitigate or eliminate any risk, even when we're talking about the use and the pooling of competitors' sensitive, granular, real-time information, because in many instances, this could actually mean not only that effects, it'll determine effects like the prices in the market, but it actually is not, it's independent decision making. Even though the data, the inputs are common, the formula is different. The second thing is that many of these tools charge on a fixed per transaction or per final sale basis, such that the tool provider itself, when it's thinking about maximizing its own profits, it may want to maximize volume sales, right? It wants its customers to sell as much as it can, as opposed to restricting output through a cartel price. My second point is I want to touch on the efficiency justifications. So I agree that there certainly can be higher prices that harm consumers and competition, but there can also be lower prices. And I think very importantly, AI tools can get us to lower prices more quickly than without the tools. So there's some empirical evidence, for example, that during the pandemic, the adopters of certain AI tools lowered their prices more quickly than the non-adopters. I think that these tools can be particularly beneficial to consumers in times of regular demand shocks. And then there's perhaps a more challenging case, but the instance where these tools result in higher prices. But I think it's important to remember that there might also be efficiencies and other legitimate reasons for higher prices. So for example, sellers, particularly small sellers that don't have the army of data scientists or access to the sophisticated tools of large buyers, these sellers may be underpricing, and along with that, maybe having lower quality goods or services. And so use of an algorithmic pricing tool may result in higher prices for these sellers, but that's not necessarily because of price fixing, but rather access to better information. I think we can all agree that responding to market forces is a good thing. If there's scarcity, prices should reflect that. And my final point is a policy implication. As many of us know, there's a lot of uncertainty in antitrust enforcement by some of these statements of interest and withdrawals of safe harbors. And there's also a lot of state laws that are actually prohibiting conduct or certain conduct. And so as a policy matter, I think that we need to be very careful before outlawing or increasing the risk of allowing competitors to use common technology to price more efficiently, because it can actually benefit the larger players who have the resources that are required to build the infrastructure to have their own proprietary tools that allow them to price efficiently. And I'll stop there for now.
That's great. I mean, I think those are important considerations of not only the concept of agreement, but taking a look at how do algorithms really work and what are the real market effects, which enforcers and practitioners and any stakeholders should be aware of. So we were examining the concept of agreement, and now moving more into how these theories play out in litigation. We have a US docket packed with very, very, very exciting cases that analyze these points, including RealPage, Gibson, Cornish, Yardley, and Argristats. Judge Ginsburg, would you please walk us through these cases?
Sure, Camila, and thanks for including me in this panel. It's kind of very interesting. As far as I know, the only decision so far from a federal appellate court is in Gibson against Senzing Group, which came out just in August of this year. So let's start with that, a case that involved the use of pricing software by hotels on the Las Vegas Strip. The plaintiffs there alleged, and the district court dismissed, two separate claims, one being a hub and spoke conspiracy claim that was not appealed, and the other, more continuing interest, that the hotel's licensing agreements with the software provider in the aggregate artificially raised prices. And the plaintiffs did appeal the dismissal of that claim. So the court addressed Section 1 liability as it relates to algorithmic pricing and ultimately affirmed dismissal of the claim, but it's of some interest. The court reasoned that even when competitors, I'm going to quote it, are aware of their competitors' adoption and use of pricing software, their independent decision to use the same software, followed by higher prices, is not sufficient to state a Section 1 claim. And the reason is that otherwise, holding competitors liable for using the same vendor could, again, quoting, could ultimately harm competition, as it would take away a means by which competitors might compete. Close. So what was missing from the complaint then? Well, the court said that an allegation that software shared the confidential information of each competing hotel among the licensees might have changed its analysis, but that was not alleged. And the court also explained that an agreement among the hotels to abide by the software's pricing recommendations would undoubtedly violate Section 1, but again, that had not been alleged. So that's all we take away from that case. In the RealPage case that you mentioned, RealPage rental software, the plaintiff tenants there, these are apartment tenants, alleged a per se price-fixing conspiracy by a software company that collected sensitive pricing supply data from their landlords, and then using an algorithmic pricing tool, provided those landlords with recommendations for increasing the price of each rental unit. The district court denied RealPage's motion to dismiss and concluded that the plaintiffs had not alleged the conspiracy justifying the application of a per se standard, but that they had plausibly alleged a Section 1 violation under the rule of reason. So why not per se liability? Well, first, they didn't allege that when the various landlords joined this conspiracy, if there was one, or at the time they joined, and this could be a helpful fact. The court didn't go into depth, but I think the point is that if they all joined close in time, it's more likely that the word went around that this was a way in which to cooperate below the radar screen. Second, there were no allegations of agreement or even of any direct communication among the landlords. So the only communication was vertically between the landlords and the vendor. Third, there was not a complete delegation of pricing power to the RealPage company. In fact, their pricing recommendations were not implemented by the landlords some 10 to 20% of the time. Fourth, RealPage monitored the landlord's pricing, but there was no enforcement mechanism to remove or to punish an uncooperative member of the purported cartel. And then finally, I should point out that courts have generally hesitated to apply a per se standards, new technologies, or novel business strategies. That's appropriate because the premise of per se condemnation is that the repeated experience shows a practice is almost always anti-competitive, and that degree of experience is lacking when a practice is new on the scene. This was a feature, by the way, in the Microsoft case as well, where the court declined the government's suggestion, this is 2001, for per se treatment of certain practices. So based on these considerations, the court did not view the alleged conspiracy to be a traditional, straightforward price-fixing conspiracy. So what evidence of plausible coordination did the court find for the claim to survive the motion to dismiss and go into, let's call it, rule of reason land? The court found and said, quote, the most persuasive evidence of horizontal agreement, close quote, was that the client provided RealPage with proprietary commercial data, quote, knowing that RealPage would require the same from its horizontal competitors, their horizontal competitors, and use all of that data to recommend rental prices to its competitors. So this is data pooling from the various landlords. And the court explained that this allegation made the critical difference between this complaint and the alleged hub and spoke conspiracy that the district court had dismissed in Gibson Sending, and saying, as the Gibson court acknowledged, a successful hub and spokes theory of Sherman Act liability based on the use of algorithmic pricing depends in part on the exchange of non-public information between competitors through the algorithm. That is what the multifamily plaintiffs have alleged here. So that was a key difference in rationalizing per se. RealPage monitored adherence to its price recommendations, and it required its client landlords to justify their decision if they overwrote the recommendation and didn't price as recommended. Duffy against Yardi Yardi Systems, the Western District of Washington, also very recent, December 2024. This similarly involved an alleged conspiracy between a revenue management software company and a group of residential property owners involving three types of agreements. First, vertical agreements between Yardi and each client to use their software. Second, a horizontal agreement among the clients to share commercially sensitive information with Yardi, to use the software and to implement its recommendations. And third, a shared understanding that Yardi would use the information to recommend super competitive rental rates. That was the pitch for joining. So the court concluded that the plaintiffs had plausibly alleged agreements under a sort of invitation and acceptance theory and under parallel conduct theory. So focusing on parallel conduct, the court said the plaintiffs plausibly alleged that the landlords had agreed to engage in parallel conduct by, quote, agreeing to use Yardi's products, delegating their pricing decisions, and deprioritizing occupancy in favor of algorithmic pricing. In other words, they weren't going to strive to fill rent every unit at the best price they could get. They were going to get super competitive prices for as many units as possible, and that would more than compensate for having some vacant units. The cited plus factors. The client provided Yardi with commercially sensitive data, knowing that it was going to get the same data from their competitors. And sharing data and raising rental prices, regardless of occupancy, would not have been in the economic interest of any one landlord unless it knew its competitors were going to do the same thing. Now, the court nonetheless disagreed with the RealPage decision and concluded that the plaintiff had alleged a per se violation. Explained that the RealPage court, quote, went back and reevaluated various deficiencies in the plaintiff's allegations regarding the existence of a conspiracy, close quote, to justify application of the rule of reason rather than just considering what the plaintiffs had plausibly alleged the conspiracy. So in contrast, for the Yardi court, if the plaintiffs have plausibly alleged the conspiracy, the court goes on next to determine only whether that conspiracy is within the scope of the per se rule. And I'll quote the court, neither RealPage nor defendants here offer any legal authority supporting the conclusion that an adequately alleged horizontal price fixing agreement could be a reasonable restraint of trade. Therefore, the plaintiffs have alleged a per se violation of Section 1. I think there's just one other case to touch on, and that's AgriStats. This is a totally different industry, moving away from rental real estate. This is about the company offering subscription and consulting services to meat processing industries, pork, turkey, chicken. The AgriStats collected non-public information from its subscribers about their operations, compiled data into a report that is then distributed back to the subscribers, and compared their sales and production to the rest of the industry. So this is a government case. The government alleged that AgriStats reports and counseling services violated Section 1. And the district court denied the defendant's motion to dismiss on standing grounds. So it's helpful to note a couple of similarities and differences between this case and real case. Similarities first, both involve an intermediary facilitating the exchange of competitively sensitive data and price information. And they both rely on an inference that a client would share that data only if expected competitors to do the same. But there are some differences. There was no delegation of pricing authority in AgriStats, so it's closer to a classic information sharing case. And delegation of pricing authority to an algorithm creates different and perhaps novel risks. For example, an algorithm might reach a collusive solution simply by trying to optimize profits. These novel risks are likely not present in the AgriStats case. Although the data was anonymous also, government alleged that a subscriber's data could be de-anonymized easily, which means these could be information sharing between the spokes of a hub. There is one more, it's multi-plan health insurance provider. Switching industries again, this case about rate calculation software service contracting with insurance companies. The plaintiffs are healthcare providers who allege that the payers agreed to fix prices for out-of-network services, that is, to lower the prices that they would pay, by sharing sensitive information that the software company used in its algorithm to so-called align the payments to providers. So the district court denied the motion to dismiss and concluded that the plaintiff healthcare providers had alleged a per se illegal hub and spoke price fixing agreement. The district court reasoned that the payors, quote, do not have to use multi-plan in identical ways where there used to be considered parallel conduct, close quote. So it would be sufficient, the court said, if they agreed to abide by a third-party algorithm that guarantees a below-market payment. In other words, quote, an agreement to fix prices within a below-market range through use of an algorithm is no different from antitrust purposes than an agreement to fix prices to a single point. Close. So the court found evidence of parallel conduct with certain plus factors. The payors switched from traditional benchmarks and multi-plans rate calculation and negotiation services, and the plus factors were using multi-plan without an agreement among insurers would not be in their self-interest, not in the self-interest of anyone, because they would risk losing policyholders to rival insurers. The presence of various market conditions that tended to facilitate an agreement. So this was an area with high barriers of entry and exit, high market concentration, a history of past collusive conduct. So the court said that although general allegations concerning the structure of a market are insufficient alone, they are relevant when considering whether the plaintiffs otherwise plausibly alleged an agreement. Now bear in mind that all of these cases are very recent. There's only one appellate court resolution. There are a few key takeaways I would suggest briefly, that at least for now, these cases ordinarily should be analyzed under the rule of reason rather than their per se standard. We're dealing, obviously some look just like per se conduct, but otherwise, we're dealing with novel technology. The pro-competitive benefits, the underlying algorithms are not well understood, at least by courts at this point, nor is the difference always clear between data pooling, as in RealPage, and data sharing, as in AgriStats, especially when a party could see anonymous confidential data, which again further supports a case-by-case approach. So we should treat all confidential data equally. That's another point. A case-by-case approach will help courts develop a better sense of which data are more likely to give rise to competitive concerns, considering the granularity, sensitivity, and timeliness of the data. If you go all the way back to American Element Lumber in 1921, Supreme Court relied there in part on the forecasting aspect of the data, as well as granularity and relevance to facilitating coordination. The timing of the data matters a lot. The cases we've discussed today do not involve forward-looking data. As the Supreme Court said in its most recent case on this subject, with Gibson in 1978, U.S. Gibson, quote, the exchanges of current price information have the greatest potential for generating anti-competitive effects, and although not per se unlawful, have consistently been held to violate the Sherman Act, close. And before that, the way in maple flooring manufacturers, the court held that no violation occurred when the relevant data reflected past averages and aggregates. So we're treading in highly fact-intensive ground here. We have to be quite careful before adopting sort of sweeping condemnations.
Thank you, Judge. Corinne, shifting to how maybe a different way of looking at these things, at these matters, how has the DOJ and FTC statements of interest in these cases explained the matters or offered legal theories to solve them? And what do the guidelines from the Biden administration and the Trump administration say to market participants?
Sure. So there's four important statements. There's the statements in RealPage, in Yardy, in Multiplan, and Gibson. And importantly, three of them were filed during the Biden administration. But I think that the March 2025 statement from the DOJ and Multiplan nicely illustrates the through line, right? That statement from March endorses the Biden administration's amicus brief in the Gibson case. So I think that's important to keep in mind. The other thing is that a lot of these are stated in terms of cans. So while there's a lot of statements that companies have found very concerning and causing uncertainty, it's important to remember that the context of these were motions to dismiss, and in a lot of cases, the government was essentially arguing against the defendant's position that certain conduct was per se lawful. So, for example, in the Multiplan case, the government, DOJ's position was that it's just because there is variance in price doesn't necessarily mean that the case should be dismissed on a motion to dismiss, and that there could be liability, they said not is, liability, if you set prices, the starting point price or a maximum price. But of course, as economists know, this will come down to fact specific. We'll need to have some kind of evidence that there's a systematic relationship between a starting point price and the actual price. In terms of, I think we're going to spend a lot of the rest of the panel maybe talking about shoulds and what things should be and whether we should have per se or truncated. And so I wanted to just step back as the practitioner on the panel and give a little bit of my takeaways from what Judge Ginsburg shared and these statements. And so I like to do this in terms of the traffic light guidance. So let's start with red zone, right? I definitely want to talk to my clients. We want to stay out of the red zone. I like the what about Bob test from then acting chair Maureen Olhausen's speech back in, I think, 2017, where she essentially says, look, if it's illegal for a guy named Bob to enter into certain agreements with competitors to set and prices without an algorithm, then it's also illegal to do it through an algorithm. All right, pretty clear cut. Then let's move into the orange zone. And I think with orange zone, it's about competitors' use of a common algorithm with an enforcement or punishment mechanism that results in higher prices. I think that the higher prices for all of these really matter. While it technically, I guess, could be per se illegal to set lower prices for consumers, I don't think that that's an enforcement priority for agencies. I hope not. And I don't really see the incentive for private plaintiffs in terms of getting damages. But I think this enforcement or punishment mechanism is important, and as well as the algorithm pools this granular, real-time, non-public, competitively sensitive information. I think that there's still a lot of green zone conduct, right? I think the Gibson case that Judge Ginsburg discussed, but also the kind of pricing tools commonly used by online retail platforms that are based on non-public information and allow for unilateral pricing decisions, even when these are dynamic, even when there's options to go in and set it so that your prices automatically change based on market realities. So the yellow zone, I think yellow zone is when we have competitors who agree to use a common algorithm that, again, relies on this granular, competitively sensitive information, and there's no enforcement or punishment mechanism. So then I think whether this type of conduct brings us back to green or orange, again, comes down to effects. And that's kind of where I started my remarks at the beginning of the panel, that we can't just assume that these algorithms are going to result in higher prices. And I think another nice example is the TrueCar example, back some 15 years ago, where the FTC actually investigated the dealers. TrueCar was an example of using granular individual transaction data that ended up resulting in lower prices through a race to the bottom with the dealers undercutting each other on price. And, as a final note, I'll say that this panel is titled and is limited to US and federal law. But as I mentioned before, there are some new state laws. And of course, there's some recent developments like revisions to guidelines in the EU. And I know the OECD has done a lot of work, and they have a nice paper that I recommend from October of this year that summarizes some of the initiatives around the world, some of the market studies and other things, particularly the way that agencies, the major agencies around the world, are thinking about autonomous collusion.
Any other views from the panel? I want to give a chance for Professor Maurice or Salil to give their views. Go ahead, please.
Yeah, hi. So, an important question to think about is whether this real page litigation, both the DOJ and private sector, represents some sort of transitional moment in antitrust law's approach to machine-mediated coordination. And I think where it does is in the view, in the statements of interest by the DOJ, the view that, it's not just price fixing in the classical sense, but it's sort of emphasizing how sharing competitively sensitive information through the real page platform and using what they term aggregated data to generate pricing recommendations could be a new form or new category of liability for anti-competitive agreement. And it'll be, it's obviously, we have to see what the courts think of this argument. I think there is a tendency towards caution for courts in these novel areas. I have sort of two observations about the sort of approach the DOJ is pushing here, this idea of a sort of a violation through sharing competitively sensitive information through the platform. Sort of the first observation is that although there is a tendency towards caution in these novel areas, as Koren Wong-Ervin pointed out, there are some pressures, particularly at the state level. I mean, we all saw, I'm sure, California's AB 325, which kind of goes beyond some of the ideas that we usually use to distinguish tacit collusion and explicit agreement, because it even considers not just non-public information, but public information used by an algorithm can trigger liability. And I think that's in part we're seeing not just that statute, but more narrower state statutes involved with real estate or rental apartments. We're seeing that the pressures, the concerns are big enough to hit the radar of public policy in the legislatures. And I think rental housing had a lot to do with that. The other thing I sort of would point to is, and this is maybe a bit of a quibble, the DOJ is talking about using aggregated data to generate pricing recommendations. And in a few of these cases, and notably in the Cornish Adebayo case, there was a focus on whether the data is pooled or not. And I think in some ways we need to get a little more technical education on these things, simply because if you talk to computer scientists, if you had a series of data sets, right, and you had, think about 25 years ago with the old HTML internet and how we had these web crawling bots, right, that just went from one web page to another. Similar to that, right? You could have a software bot that crawls through the data sets without pooling the data sets and comes to an estimate or a prediction. So it is actually possible to do the sort of forecasting that courts were concerned about, even in, an American column from the data, without actually pooling or aggregating all the data. You could maintain those data sets separately. And so at that, I'll turn it over to if someone else has some comments on this.
Yeah, if I could just follow up on this, I would be a little bit more cautious in advising clients, because I would first want to look at the competitive impact statement and the final judgment in the Graystar case in terms of boundaries. And then also, as Salil mentioned, the Cartwright case, the Cartwright Act, rather, California, as well as the amendments to the Donnelly Act, where even historical publicly available data can lead a firm to liability. And so what's the underlying concern? How come they're not as reserved as or the like? And maybe going back to U.S. The American column lumber case that Judge Ginsburg raised, you could actually see some parallels here, that you have forward-looking data in RealPage because it involved not only past data, but also future occupancy rates and trying to smooth the demand and the like. So that was the forward-looking data. And in American column lumber, I love teaching this case with my class, you had that skilled interpreter who was then telling the participants what to do. And here, as Salil mentioned, that skilled interpreter could be the algorithm itself. And the interesting thing is that this arose not in the market that you originally would have thought. I mean, you would have thought like gasoline, that's going to be like the candidate case. But the litigation here in the United States was through apartments. And that was really Heather Vogel who uncovered this through ProPublica and the research, and also led the DOJ to conclude that there are significant anti-competitive effects in this industry, which may not fit the traditional forms. So what I find heartening from the courts, both in Yardy and Judge Crenshaw and RealPage, is the sort of intuitive approach that something is not right here. Why would a rival actively share information with its competitors, knowing that that could potentially be used against it by the algorithm, unless it really was to raise all the ships? And I think that's why, and also the interesting thing, Judge Crenshaw did not foreclose per se. The only thing Judge Crenshaw did in the RealPage case is said we're not going to apply the per se at the pleading stage. So he left open the possibility of applying the per se rule after discovery. Now, whether or not that's going to happen, but at least he didn't foreclose that opportunity.
So kind of segueing a little bit into the actual effect. So Dr. Deng, from an economic perspective, what are the potential effects of using, like these cases say, a common starting point for prices or a common pricing formula like the RealPage alleged? Does this make markets more transparent, and do more transparent markets mean more collusion or less collusion?
Sure. Happy to offer an economist's perspective. From an economics perspective, the concern with competitors agreeing to use a common starting or reference price, or even agreeing to use a common price formula, it's fully justified, right? Of course, I also agree with Koren that facts matter. So just hypothetically speaking, for example, let's say competitors sell largely homogeneous products, right? And let's say the common reference price happens to be the competitive price that matches supply and demand. And so that price would be the most economically efficient price in any event. Now, I want to quickly address this other question about information exchange and transparency. The standard view is that more transparency usually makes it easier for companies to collude. The logic is straightforward, right? Collusion is easier if companies can monitor one another and quickly spot any cheating or deviation from their agreement. Now, it turns out that transparency or information can actually be a double-edged sword. in some situation, certain types of information can make collusion harder, not easier. And obviously, that's not what a cartel would like, because that tends to undermine the stability of a cartel. So let me give a quick example in the interest of time. Let's take a cartel that divides up a market. So let's say firm A sells only in one region and firm B in another. Now, in that kind of arrangement, monitoring and detection is easy. So firm A sees one of its customers buying from firm B in its own region, then firm A knows that firm B is cheating. You don't need any additional information. Now imagine that these firms also share detailed price information, sales information, and let's say one firm is doing exceptionally well, posting high prices, higher sales, and high profits. Now that information can tempt other firms, attract other firms, especially those with excess capacity, to basically jump into the other's territory and try to grab that extra profits. Now, without that insight, without that knowledge or information, the temptation just isn't there. So you can say that's out of sight, out of mind. Now, there are many other examples uncovered in real cases and in the literature. I think the point is that while transparency often helps with monitoring and coordination, it can also make cheating more attractive. So when I evaluate the role of information transparency in cartels, I always want to think carefully about how a piece of information affects basically all three things: monitoring, coordination, and also at the same time, the incentives for deviation and cheating.
That makes me think of, I think, Maurice, correct me if I'm wrong, in one of your papers, you talk about sort of the importance of the tools on the buyer side. And so thinking about transparency or information, it makes me think of the symmetry. And, you also have some of these tools on the buyer side, I think that can incentivize cheating or deviation, greater incentives, because if the buyers know quickly when somebody lowers their price and you can buy a bunch, then, that's one reason.
Yeah, I mean, absolutely. I mean, I think we all are in agreement that it's really going to depend upon the facts and the market conditions in that particular industry, right? I mean, no matter how many people use algorithms, there may be markets that are just not going to be susceptible to algorithmic collusion. And so we don't have to be concerned about that. And then there might be countervailing measures that we can have to help destabilize any sort of, let's say, tacit algorithmic collusion. The tough issue, and I think this is where Judge Ginsburg was talking about, is how do we characterize a set of vertical agreements, which was alleged in the Ninth Circuit, from a hub and spoke, right? And that's really the nub. And I think for Judge Crenshaw, he didn't really have that difficulty, because what he said is, why would every month competitors share such commercially sensitive information unless they knew that it was going to raise all boats? But you can imagine in other scenarios where the first company decides to use an algorithm, no problem. Second, third, at what point then does that tip to a hub and spoke? And I think that's sort of like some of the issues that Salil meant to Judge Ginsburg, and Koren raised as well.
I agree on the importance, obviously, in every antitrust case, I think, on the being fact specific. I'm very nervous. I get really worried about the per se approaches that don't, without an absence of, to me, an agreement where the invitation that's sort of advertising, and then people can just accept because they participate, they use the software and they give their data without more, kind of more plus factors, because I think that there's a real chilling effect, right? A lot of companies are not willing to go to court and fight. Investigations are costly and disruptive and resource intensive. And so the Yardy decision is troubling for me in some of the positions by the DOJ.
Well, about the point Maurice raised, when you have the first, second, third joining as customers of the vendor, a consideration that I didn't mention, but it shows up in a couple of the cases, is the degree to which the customers represent a large market share. In AgriStats, the government case, it was 80 to 90%. So if you have 1, 2, or 3, and that might be a very small percentage of the rental market. It also might be very large in some other market.
So shifting now, and with all of these cases in mind, now moving into the practical side, what should companies take away and how can they navigate these risks in the compliance framework? Corinne, drawing on your experience at the FTC and in private practice, what practical guidance would you give your clients?
Sure. In addition to sort of my traffic light guidance, which, to me, I think it always, in terms of Maurice saying maybe he would be more conservative, it also comes down to the traditional counseling questions, right? Like why now? How important is this to the business? Having been in-house at Qualcomm, if you just tell the business, no, too risky, no, risky every time, they're not going to come to you, or you can have real problems in terms of your business. Sometimes customers come and demand things. Sometimes you need to do things in order to stay competitive. And so that all goes into the risk assessment. I do think, coming back to really bringing in those computer scientists, really understanding how the specific AI or algorithmic tool works, and coming back to the key point of, is it really maximizing profits jointly?
And that point brings me to Dr. Deng. I think you wrote about the explainable AIs. Can you tell us a little bit about that?
Sure. Explainable AI, I think that fits into compliance quite well. And the idea is that basically to open up the black box of AI. I kind of typically use an example to demonstrate or illustrate how the modern XAI works. So you can imagine, you have an AI pilot trying to learn how to fly by experimenting with different controls. And over time, the AI pilot can get really skilled, but it's often unclear why does the AI pilot take certain actions in certain situations. Now, XAI is as if you have a co-pilot documenting the entire learning process, right? So with every control, every maneuver, the co-pilot is recording the temperature, the wind speed. I'm not a pilot, so and everything else, right? So at the end of the training process, the XAI co-pilot is able to inform us of the reasons as to why this AI pilot takes certain actions. So I think that idea applies to algorithms as well. If we're able to incorporate or integrate XAI in the development of these pricing algorithms, then we'll have a better chance of understanding how they behave and why they behave in a certain way. And that information, I think, it's helpful regardless of how the case laws develop.
So compliance by design is actually a really good idea.
Exactly. And I think that's where the technology should move towards, given just the prevalence of these AI technologies and all the regulatory focus on this technology.
Before closing, I would like to give everyone a chance to give some final thoughts and share any sort of takeaway you would like the audience to have, starting by Judge Ginsburg.
I think everything is worth saying has been said. It's very intensive. It's going to be for a while until we have more experience. And we need more scientific, technical input from the beginning.
Maurice?
Yeah, so the question I'm most frequently asked is, in what other industries should we be concerned about? And what other types of collusion should we be aware of? And I think the one area that, you have a few field studies, but I think more field studies would be better. I'm not as optimistic about the efficiencies story to date from the field studies because it's mixed, and I don't see a compelling case for efficiencies in markets that are conducive to collusion. So I would think a stronger case about efficiencies, just generally greater skepticism about efficiencies. And then the third thing is that if the clients are going to push back, I think that's our role as counselor, that we have to say, look, this is the law. You don't want to violate it. And if their algorithms are causing super competitive pricing and are harming millions of individuals, particularly when you think about rent prices and how important that is for so many households, that the clients should be aware, and they should look at the consent decree. They should look at the state laws and realize, all right, we need to tread a little bit more carefully.
Salil?
Yeah, I'd just like to say thank you for hosting this webinar. I generally agree with the point of Judge Ginsburg about treading slowly with novel industry developments. However, I think this is an unusually broad development with a huge impact that is, as I mentioned before, the courts are racing against things like California's legislature, and the technology itself is advancing in ways that is likely to put pressure both on the courts and on the legislatures and maybe other ways. We're starting to see personalized pricing being incorporated into these algorithmic software tools, such that your rent may not own, or your rental terms may not only be dependent on what the bot or the algorithm predicts, but also what it knows about you. And I think that's going to be tremendously unpopular as it proceeds, and is the kind of thing that forces legislators to act.
Corinne?
Sure. I'll just say, my point about the business not coming to you, I think that's what I should have clarified. I meant, like, if you're giving overly conservative advice. And so I think that the traffic light guidance I gave is where I think the courts are and where I think enforcement priorities are. I think it matters in terms of what's the expectation or the research show or the intent. Are you trying to charge super competitive prices and restrict output, or are you trying to price more efficiently?
Dr. Deng.
I would just say that. Yeah, so I would just say that this is an extremely active and exciting area of academic research, and it's becoming increasingly interdisciplinary. So when I started looking at this topic about 10 years ago, there was somewhat limited research, but today this topic has attracted the attention of researchers in economics, computer science, AI, machine learning, and even operational research. So I'm seeing new research studies being published almost every other day. So I'm keeping a very close eye on the development of the literature. I recommend everyone does the same, because I truly believe that those efforts are going to really help us better understand and better address the risks of algorithmic collusion. So thank you, Camila.
Thank you all for this very exciting conversation.
Yeah.